This is an area of developing law. Certainly in the Ninth Circuit where I practice, this is fairly new terrain. In order to understand what's going on, I think it helps if we take a couple of steps back to understand just a couple of things about Chapter 7, and that will set the stage for this really new developing law. So in Chapter 7, we just erase debts in one fell swoop. The whole process typically takes between 5 and 6 months from the day we file the papers until the day the debtor gets the discharge. And then once the debtor gets the discharge, and I'm thinking of individual debtors, not business debtors in this context. Once the debtor gets the discharge, those debts that are of the dischargeable variety are just wiped out without the debtor paying anything. Well, of course, from the creditor's perspective, this is a bit of a hit. So there are some limitations. One limitation is getting in the door in the first place. And Congress has given us a 3-part test to determine eligibility for Chapter 7 protection. I realize most people think in terms of a 2-part test, the so-called means test, but there is a 3rd part. So the first 2 parts of the test are what's referred to as the means test. And the idea behind this test is to weed people out of bankruptcy in Chapter 7 who have the resources to pay their creditors something in some other chapter, say Chapter 13 or Chapter 11. So in this 2-part test, the first chunk, what we do is we start with what's called current monthly income, which is the 6-month arithmetic average of gross income for the 6 full calendar months immediately prior to the day the debtor files the bankruptcy papers. We annualize that by multiplying by 12, and we compare the result to the median income for a family of the debtor's size. If the debtor's below that median income, that's pretty much the end of it. The debtor's in the Chapter 7. If the debtor is above that median income, then we go to the second part of the test, in which we go back to that 6-month arithmetic average of gross, current monthly income, and from that we do some subtracting. We subtract out what the debtor pays in taxes and Social Security. We subtract out living expenses, starting with IRS standard living expenses for the debtor's family size. And then we subtract any additional living expenses the debtor might have that aren't envisioned in the IRS standard expenses. The result is something called disposable monthly income. And the reason we do that is to determine whether or not the debtor has money left over after covering reasonable living expenses to pay creditors. Now, keep in mind, one thing we do not subtract out are payments that the debtor is making to creditors on things like credit cards. Because remember, the goal is to find out how much money is left over to pay those creditors. So we don't want to double count. All right, that is what's called the means test, that 2-part test, and it is the embodiment of Section 707B2 of the Bankruptcy Code. Now, I mention that because Section 707 is the only section in the entire Bankruptcy Code under which a Chapter 7 individual case can be dismissed. There is no other section of the code that can be used to dismiss a Chapter 7 personal bankruptcy case. Now, I said there's a 3-part test. Why do we have a 3rd part? Well, if you think about what I just described, there are 2 obvious artificialities. The first artificiality is that the income we're using is a 6-month arithmetic average of gross income, which might not be an accurate picture of what the debtor's income is doing marching into the future. Because, for example, if the debtor had a drop in income, the 6-month arithmetic average might overstate what the future income is going to be, or if the debtor's income went up, the 6-month average might understate where the debtor is going into the future. The second artificiality is in the living expenses. We're using IRS standard living expenses for a good portion of the subtraction. And those expenses may bear little, if any, resemblance to the debtor's real life living expenses. So there is another portion of the Bankruptcy Code that takes a look at income and expenses, but real live income right now and real live expenses, not some fake IRS standard expenses. And we take the difference of income and expense in that other section of the bankruptcy papers, and we get another candidate for disposable monthly income. Now, why do we do that? Well, because sometimes people are living more frugally than the IRS standard family, and there may be money left over to pay creditors. All right, let's take a step back and go back to that section 707B of the Bankruptcy Code. That B2 is where we got the means test. Well, B1 has a very important provision. It says that section 707B only applies to a case in which the debtor's debts are primarily consumer debts. So if the debtor's debts are primarily non-consumer debts, for example, they might be tax debts or they might be business debts, then the entire section 707B does not apply. So the U.S. Trustee's Office would not be in a position to seek dismissal of the case under section 707B because it doesn't apply. But if the debtor still has that money left over each month, the U.S. Trustee's Office may take the position, well, this is somebody who should be repaying his or her debts in some kind of a repayment plan. Well, the two other chapters that we typically put people in that have repayment plans are chapters 13 and 11. Now, the Bankruptcy Code makes it very clear you cannot force somebody into a Chapter 13. So the U.S. Trustee's Office cannot ask the court to convert the case to Chapter 13. Why? Well, this is a somewhat arcane piece of information for you. It turns out that the 13th Amendment to the U.S. Constitution is implicated, and this may be the only time where you see an actual application of the 13th Amendment. What is the 13th Amendment? Well, the 13th Amendment is the amendment that was enacted just a few months after the Civil War ended, and it prohibited and does prohibit involuntary servitude in slavery. All right, so the Congress, in enacting the Bankruptcy Code, concluded that forcing somebody into a Chapter 13 case would violate that 13th Amendment protection. So you can't force somebody into a Chapter 13. Now, way back in about 1992, the U.S. Supreme Court handed down a decision in which it was asked about the application of the 13th Amendment to an individual Chapter 11 case. At the time, there was a fundamental difference between Chapters 13 and 11. Actually, two main differences. The first is, in Chapter 13, the debtor was required to devote post-petition earnings, that is, earnings earned after the filing of the bankruptcy petition, to making planned payments in a Chapter 13 payment plan. That was not a requirement in Chapter 11. The second was that post-petition earnings went into the bankruptcy estate. That also was not a provision in Chapter 11. So the Supreme Court said, well, it's true that you can't force somebody into a Chapter 13 because that would violate the 13th Amendment to the Constitution. But there is no such prohibition when it comes to Chapter 11 because there aren't those two provisions in Chapter 11 that do appear in Chapter 13. Well, in 2005, Congress enacted something called the Bankruptcy Abuse Prevention and Consumer Protection Act, sometimes unaffectionately referred to as BAP-CPA. And that act changed Chapter 11. Actually, it changed a whole lot of the other portions of the Bankruptcy Code. But what it did was it introduced those two missing components in Chapter 11 that had been in Chapter 13. So now in an individual Chapter 11 case, the debtor must devote post-petition earnings to plan payments, and the debtor's post-petition earnings go into the bankruptcy estate. So you would think at that point, it must be clear. The 13th Amendment would apply, and you couldn't force an individual debtor into a Chapter 11. Well, as a result, there wasn't a lot of activity on trying to get individual debtors into Chapter 11. But there is a provision one section of the Bankruptcy Code prior to Section 707, that's Section 706. And in Section 706B, the Bankruptcy Code does say that a party in interest can move the bankruptcy court to convert a case to Chapter 11. Now, I think we can all agree that if such a motion were filed in a non-individual bankruptcy case, there wouldn't be any problem with the 13th Amendment, because the 13th Amendment doesn't protect businesses. It doesn't protect partnerships. What it does is it protects individuals. However, recently there has been movement to apply Section 706B to individual bankruptcy cases. What does that mean? Well, it means if the debtor has primarily non-consumer debts, meaning Section 707B is not applicable, so the case cannot be dismissed, then the U.S. Trustee's Office and also the IRS, and in one case in San Francisco, an individual or a succession of creditors filed Section 706B motions to convert a primarily non-consumer individual debtor case to Chapter 11. I had such a case just recently, and the judge granted the motion that was filed by the IRS to convert the case to Chapter 11. We are appealing that decision right now. And I will say the judge felt a little uncomfortable with granting this motion because, well, how does one force somebody to comply in a Chapter 11 if that person doesn't want to comply? So this is a somewhat arcane bit of law, I suppose. It's something that's very much cutting edge and it's developing. So how does this apply in your case if you're listening to this video right now? Well, prior to this move to apply Section 706B to individual cases, if I had a client who came in who had primarily non-consumer debts, most of the time it was either business debts or tax debts, I would say, well, we'll just pop you into a Chapter 7 because we don't have to worry about the means test. You don't have to even complete the means test in the bankruptcy because the means test is the embodiment of Section 707B2, which is taken off the table in a non-consumer case. But now, if I have a high-income person who comes in with primarily non-consumer debts, I'm going to have to warn that person, well, if your income is high, there's a very good chance that there will be a motion under Section 706B to convert your case to Chapter 11. And Chapter 11 is the most complicated chapter in the Bankruptcy Code, and it's concomitantly the most expensive. So in that situation, I might suggest if the debtor is eligible for Chapter 13, to try a Chapter 13 instead, because it's much less complicated than Chapter 11. It does have a multi-year debt repayment plan, but it doesn't have all those complexities that make it so much more expensive. Whether we win on the appeal or not remains to be seen. I think the 13th Amendment argument is a very strong one, and this may be one of those things that eventually bubbles up to the U.S. Supreme Court. There have been a few cases around the country, practically none in the Ninth Circuit where I practice, but there have been a few cases, and they've all been at the lower level, the bankruptcy court level. So what we need now is to see what appellate courts will do and to see whether this will go up to the U.S. Supreme Court if necessary. Because if the Supremes rule on this, then it's binding on the entire country based on a doctrine called stare decisis. In essence, what it says is the thing has been decided and therefore it is binding on all courts below that particular court. So if, for example, the Ninth Circuit rules on this, then the Ninth Circuit's decision will be binding on all courts in the Ninth Circuit. Of course, it will not be binding on other circuits. And so that's why this may end up having to go to the U.S. Supreme Court. And that's because the U.S. Constitution says that one of Congress's enumerated powers is to develop uniform laws on the subject of bankruptcy. So we really want to have uniform laws throughout the United States. So this is I consider a very interesting area of law. It's an unsettled area of law. And so if you're in the situation where you have fairly high income and primarily non-consumer debts, this might be one of those areas where you don't want to roll the dice and do a Chapter 7. Maybe you want to think in terms of either a Chapter 13, or if your debts are simply too large to qualify for Chapter 13, a Chapter 11.